Well, I want to thank everybody for tuning in to California Times. My name is Guy Meyer, and today I'm visiting with Kathryn Mickle Werdegar, who has just last year retired as a California State Supreme Court judge. I almost messed that up. Kathryn, it's a pleasure and an honor to be here. I understand you've served for 23 years on the California State Supreme Court. Can you give me a little background, maybe from the beginning? How did you ever get to that position, going back in years back?
That's a fair question. People have sometimes asked me, did you always want to be a judge? That's really very funny. I graduated from law school in 1962. 1% of attorneys in the country were women at that point. In California, it was 3%. I'd never heard of a woman attorney before I went to law school. There were 2 women in my class at Berkeley Law. My husband and I were living in Washington, D.C. after I got my degree, and my first job was in the Kennedy Civil Rights Division during the Civil Rights era. If your viewers have watched The Green Book, that movie, that was the era. And Martin Luther King was marching, etc. That was my first job. We came back to California, and in due course, I interviewed at the Attorney General's office and with a private firm, but they weren't hiring women, or they weren't hiring me. But I never considered that it was discrimination. There were just no other women around. So, but as my career unfolded, I became academic dean at the University of San Francisco Law School. I clerked for a California Supreme Court justice, and from that position, Governor Pete Wilson, who had been my classmate at Berkeley Law, appointed me to the California Court of Appeal. When the judge for whom I had clerked on the Supreme Court retired, I was elevated to the Supreme Court. I think that's a bit of California history, that a former law clerk would fill the seat of her former justice.
Is there even more of a special story behind that that connection? Were you maintaining a friendly contact? Did it
Oh, you mean with the governor?
or with the Supreme?
The justice that I clerked for. Yes, absolutely. And the governor and I were acquainted, and at that time in his administration, he was probably looking for women. I was the right time and the right place with the right credentials. As you know, chance favors the prepared mind, and I was prepared.
That's great. And that was back in 1993.
Yes, 93 or 94, I was elevated to the Supreme Court. But mind you, I got my law degree in 62. In the interim, of course, the world has changed. Where women were not welcome, all of a sudden, entities were looking for women, as they continue to do today.
And when you were serving as a law clerk, was that you weren't a practicing attorney at the bar? You were.
Well, you had to be a member of the bar, but I was assisting a judge.
Now, tell me in the makeup of the Supreme Court in California. Every state probably has a Supreme Court that is. Are they all called? Each state do they call them all the Supreme Court of Nevada?
They do. In California, I would quiz your viewers. They probably can't say how many justices we have. We have 7. And when I joined the court, I was the 2nd woman on the bench at that time and the 3rd woman in the history of the state. Most of your viewers have probably heard of Rose Bird. If they've never heard of anybody else in the history of the court, they've heard of Rose Bird. So I was the 3rd ever to join, and there were 2 women. When I left the court 23 years later, we had a majority of women. And we may have been the only state court in the country that had a majority of women at that time, but I'm not saying for sure. We also have an extremely diverse court. We have Asians, we have African Americans, we have Hispanics, we have women. California, as you would expect. And former Governor Brown had made 3 of the appointments of my colleagues by the time I left. While I was there, the appointing authorities were Governor Pete Wilson, and then Governor Gray Davis, and then Governor Arnold Schwarzenegger. And they each appointed somebody that they hoped would be appropriate from their point of view.
And generally speaking, it's an appointment for life?
Oh,
unless
absolutely not.
No?
On the United States Supreme Court, the federal system, it is for life. Every state has a different system. Our state has, first of all, there's no contested elections. You get appointed, there's a hearing by a commission, and there's a body that confirms you. We have to stand for retention every 12 years. But nobody can run against us. It's strictly an executive appointment. But the voters, as they did with Rose Bird and two of her colleagues, they can fail to retain you when you're up for retention. That's the California system. Some states you read about, anybody can run and contest a Supreme Court justice.
Well, that is fascinating. I didn't understand that part of history. So when Rose Bird, she was the chief, wasn't she?
She was the Chief Justice.
And she lost her position.
Three of them did. Justice Joe Groden, Justice Cruz Reynoso, Jerry Brown appointees, and Chief Justice Rose Bird.
That was a kind of a critical moment, wasn't that? Obviously,
It was a very critical moment.
And what year was that?
I can't tell you, but I was working at the Supreme Court at the time, and most of us were stunned that voters could actually recall. But that's the fail-safe safety valve for the electorate if they're terribly dissatisfied.
Right. And most of that, for those who don't know, most of that dissatisfaction with Rose Bird, wasn't that right around involving the death penalty? Wasn't that the primary issue?
That was the issue that the voters got exercised about. But the money behind the recall was about their tort judgments. That particular Supreme Court, if you can say we have different Supreme Courts, which we don't, it's all continuity, but that they were announcing new principles about consumers being able to sue for injuries from products. It was tort law. And judges create tort law. Statutes do not. So that court was interested in expanding the rights of consumers and individuals. So it was the business interests that financed the recall. But the public was, the conversation about that recall was that the court would not affirm death penalties, which they were not. They were not. There was a new death penalty law. They were trying to work their way through it. I cannot speak to their personal views on the death penalty and whether they ever would affirm a death penalty. You're absolutely right. They were not recalled. They were not retained because the public was exercised about the death penalty, as the public continues to be.
Indeed, because it just, was it 2 years ago or so that they once again reaffirmed?
2 years ago, by way of initiative, we had conflicting initiatives on the ballot. Abolish the death penalty, speed up the death penalty. By a small majority, the electorate said speed it up. I'm told that in the next 2 years there'll be another initiative, abolish the death penalty. That's been on the ballot many times. It has never passed in California.
It's, I don't know where to begin to even ask a question, but there are some 600 plus inmates on death row.
Yes, there are.
Right now. And it hasn't been entirely resolved yet. Gavin Newsom has somehow said
the court is under mandate to follow the electorate initiative that said speed up processing these cases. And my understanding, I'm not at the court now, but is that they are continuing to take the appeals, to work up the cases, to hear the cases in oral argument, and to render their judgments. The governor has said, irrespective of that, while he's governor, he has put a moratorium on it. His authority is to grant a reprieve or a stop on the death penalty. There's a little conflict there that's going to perhaps be worked out in the courts. So it's an interesting situation where the governor says, I won't enforce it, and the courts are under mandate to process the cases. After they process it, they can't do anything about the final outcome.
Let me get back to understanding a little more of the structure of the court system in California then. So you have the Supreme Court of California with 7 justices on it. And beneath the Supreme Court, is there a secondary layer?
I like to start from the bottom.
Okay, fine.
The bottom is the trial court. And most of our citizens and viewers are familiar either from a traffic ticket or from television, or although the courts are not like some of the television programs. We have 3 tiers. The trial court. If somebody loses in the trial court, as of right, they can appeal to the Court of Appeal. If they choose to do that, they can. That's the end of the line for almost every case. Review by the top tier, the Supreme Court, is discretionary. Just like the United States Supreme Court, they only take the cases they think they need to take. And in California, we might get thousands of petitions for review, as we call it, and we accept 2 to 3%.
So tell me, when you say thousands, are we talking about thousands per 1,000 per year?
I
or
am
even
no
more
no
than
no per,
1,000
no
per year?
thousands per year.
Thousands per year.
Yes, but we decide, we take and we decide about 100 cases a year. So you might want to know, well, how do you know what you want to take? One obvious reason that we have to take a case that's petitioned to us is when the courts of appeal are in conflict. We have 6 courts of appeal in the state, comprised of multiple judges. We have San Francisco, Los Angeles, Fresno, Sacramento, San Jose, and Orange County. So opinions come out of all those courts. If there's a conflict,
Being based on maybe the same
yeah, the same
intrinsic
base,
law or something
exactly,
like that,
exactly.
that,
If they
take
interpret exactly on the same issue, the same law, that's our principal responsibility, is to resolve those conflicts.
then you have to. That's
We
not
have
even
to.
a question.
And another responsibility is criminal cases where the judgment of death is pronounced. Those cases come directly to the California Supreme Court. They do not go to the Court of Appeal. Why? Well, traditionally, but I guess we want uniformity of decision in a death case. We don't want a Court of Appeal in Fresno saying one thing and weighing the evidence one way and having a Sacramento court do it differently. So the view is that the Supreme Court has the overview of the law and consistency in application of the law to the facts. The facts are always different. So those are our primary responsibilities.
And in that zone of where it's sort of the choice of those ones that you're forced to, that are in conflict,
Yes.
the ones that are involving a what do they call it, a capital case?
Capital case.
And the rest are a group decision, or how does that arrive at that?
Oh, well.
Someone takes up, says, okay, we've got to deal with this.
Oh, well, people petition. Every Wednesday morning, the members of the court sit in the Chief Justice's chambers around a table, and we have in front of us a stack of petitions that are on conference that day. We have memos on each petition from the court's central staff. Most of the judges also have memos from their own personal staff. So with those materials, which we've all perused and read, we go around the table and vote.
Is it like a hearing on each one, almost, in a way?
Well, you'd never get out of there if it were.
Right.
The most senior justice speaks first. This case, People versus Smith, I vote to deny. And they go around, deny, deny. If it's deny, but sometimes a judge will say, wait a minute, I see this issue, I want to talk about it. Or they could say grant, and a judge 2 or 3 chairs down, you go around in seniority. The most junior justice speaks last, except for the chief. So somebody will say, this is not grant worthy, or this is not a good vehicle, the facts are too muddy. Sometimes they'll say, the counsel doesn't seem up to the job of developing these issues. There's all sorts of reasons as to why we will grant or deny, but and we meet every Wednesday morning, but most petitions are denied.
They would have to be.
They would have to be, if we could get our work done.
At all.
Exactly.
And is there any element of where some external lobbying could
Absolutely.
affect or tries to affect you even looking at these?
Absolutely. And that's amicus curiae or amicus curiae. People love to pronounce that concept different ways. Those are friends of the court. They're not parties to the case, but they're interested organizations. It could be an environmental organization or a district attorney's organization interested in the issue, or it could be individuals. And they write amicus briefs, friends of the court, to help the court. That's what it means, friends of the court, but to persuade the court to take the case at this stage, trying to explain how important it is to their constituency or to the issues. So it's not just the parties. We get amicus briefs. And if we do grant a case and it's an important case, we'll get lots of amicus briefs, which can be very helpful. They might give a different slant on the case than the parties. The parties want to win their case, whereas the amicus presumably have a broader view about how the issue and the resolution will impact an industry or some other responsibility in government.
What is the realm of, I mean, certainly it must be a goodly proportion of these cases may involve large money or entities that want to do something big versus something, I mean,
Well,
I'm trying to visualize, could it be someone just in a grocery store in San Rafael who has reached this point where his case rises to that occasion, or is it something that has to have sort of has to be worth $1 million?
It could be either. No, it could be absolutely either. It could be somebody in the grocery store who has suffered allegedly, from that person's perspective, some discrimination under law. And that person is pursuing his case, and the principle that will come out of that case, should the court take it, will impact all future allegations. Maybe it's a woman who's pregnant and feels she's exposed to fumes. She's not a large industry or anything, but we have to resolve that case. Then we have cases that involve corporations that whatever we rule will impact the whole industry. So it goes from the small to the large. You certainly don't have to be people of means or money. It's the issue, the legal issue, that gets the court's attention.
Let me take a look at my list of questions here. It's an amazing world that most of us obviously have no real idea.
People do not know about the courts.
No.
They do not.
And I guess I could even back up another level for anybody a young person who maybe hasn't even got exposed perhaps enough to governmental operation. We say like the basis of our country, what I learned in high school of executive, judicial, legislature. Do you want to just give a real brief primer for somebody who...
Be happy to.
Yeah.
We have 3 branches of government, as you said. They are supposed to be independent branches of government. The executive, the legislative enacts laws. The executive applies them or tries to advance its perspective. The courts are the least understood branch of government. We are an independent branch of government. However, we have neither the power of the purse or the sword, as they say. So if we issue a ruling, we have no means of enforcing it. So it's up to the executive to advance that. And on the national stage, these days, there's little tension between various branches of government. A lot of people don't understand the courts are an independent branch of government. And they are supposed to be independent. They are supposed to stand apart from politics. Which some of your viewers might question, well, do they? And it's a fair question. But studies have been done of political systems where they don't have independent courts, and it's a completely different world. During the civil rights era, were it not for the federal courts, the world would have been a different place. They and the southern federal judges, a lot of them had tremendous courage to implement the declarations of what the law was from the United States Supreme Court at that time, because it was very unpopular in their jurisdiction.
Now, in our fabulous modern world of polarity, we tend to see, now this administration has been elected, we can finally start appointing the judges.
Absolutely.
And now, no, now this one is elected, now we can get our, is there any element of people entering that realm of being a judge where is there a real center where judges try to not be the judge of this side or that side? Is it a complicated story, or
I can only speak for how I've lived my life as a judge. Obviously, speaking of the appointing authorities in California, each governor appointed people who that governor anticipated, hoped, would reflect that governor's values and so on. By the time a case comes to the highest court, whether it's California or the Supreme Court, it wouldn't be there if it had no answer up to that moment. So of course the philosophy, the value system of the individual justice is going to impact how that justice views the case. It's a very complicated situation, but I think any judge you interviewed would say that they just try to follow the law, but of course we're creating the law when we have cases that have never been decided before. Each justice, I think, would profess that they do it with integrity and without bias, but they're human. We're human.
I remember a science fiction book from the 1960s. Now, science fiction had that opportunity for people to write and to dream about the future. Now, this one was called Stranger in a Strange Land. I'm sure if you read much science fiction. But in this book, the author created this vision of a entity in the not too distant future of a schooling of something called a fair witness, where you were basically, if you went through this schooling, you were almost like coming out as like a Zen priest. You could not, everything, assumptions were no longer a part of your lifestyle. All the past, you had to be so much in the present with evidence. And they created this realm that was almost like you could be a lawyer, but you would be a fair witness, and that people could call on a fair witness to resolve issues.
Sounds like a computer.
Could be, but in a way, is there some sort of like a Zen state of being a judge that is I'm not throwing out the word Zen. I want to confuse anybody out there, but a state where you do have to, move past assumptions, move into this place of you really try to step into the present.
Well, let me answer by saying I have signed on to opinions where the result was contrary to what I would want, because the law as developed and written, explained in the opinion, seemed to go that direction. That's not exactly a Zen state, but
No, tell me one more time on that.
I have joined opinions from the court where I would have wished the result were different. So you have to go away from your personal preferences. If the development of the law, if the opinion shows you that that's where the law needs to go.
Are you no longer a dissenter then? Can't you just dissent?
Oh, no, you don't dissent just because you don't like the opinion. You dissent because you think the law that was articulated there was wrong.
Interesting.
I have dissented on occasions, and of course every dissent cites the law, has a completely different view. You might read the majority and think that makes sense, and then you read the dissent and you say, oh. So I have joined opinions where I didn't like the consequences, but I felt that the law, after all, we don't all agree with all the law, but that the law required that. And I have written dissents where I felt that the majority misconstrued the law.
That kind of brings up the importance of taking a big look at law again, of cross-examination, where someone has made the point where if you listen to just in the prosecutor's speech in the beginning, you might have to draw a complete picture.
Absolutely.
And then suddenly the defendant, the lawyers, and then you have an entirely different perspective.
Absolutely.
And one has to have a fair cross-examination of every issue. right? And that's
Absolutely.
partly what does that go on at the Supreme Court level too?
Well, yes.
Where sometimes you might feel like you might be getting railroaded as it goes around the circle, and you have to stand up against
Well,
it.
you're supposed to think for yourself, but
Right.
you're speaking about whether to grant or deny, but
Mm.
also once a case is granted, it's assigned to a particular justice. But I want to step back. We get briefs from the parties, which is comparable to your direct examination and cross-examination. The person who is appealing or petitioning writes us a brief. If you read that brief and it's a decent attorney, it's very persuasive. Then you pick up the respondent's brief. You think, oh, it's just like you were describing. And the petitioner, the person who is aggrieved, gets the last word in their brief. So you have the opposing points of view. And then, of course, we have oral argument where you get to question or listen to the attorneys argue their cases.
Let's step back into your own personal history of the cases that you looked at over your term, and tell me, you told me just a few minutes before we started that there was one that was particularly exciting or dramatic. Do you remember that, what you were saying?
Yes, I
What was
do.
that one?
I do. That was a case, I was new on the California Supreme Court, and it was in the era when the three strikes law had first been passed. The three strikes law, your viewers might remember, was in the wake of the horrendous and horrific Polly Klaas kidnapping and murder taken out of her bedroom. And the individual who did that had a long criminal record. By initiative and also by legislation, which was unusual, the people of the state of California passed the three strikes law, and it had a very catchy 3 strikes and you're out. It meant if the defendant had had 2 prior felonies and was convicted of this 3rd felony, the trial court had no discretion in sentencing. That individual was going to prison for 20 years minimum to life. Defendants challenged that law in court. What would the problem be? Separation of powers, because the prosecutor under our system has the authority to bring charges. The judges have the authority to impose sentences within a legislative range. That law, the 3 strikes law, took the discretion away from the judges. Every court of appeal in the state to which these appeals came in the 3 strikes case said it was fine. One lone court of appeal had the courage to say, no, it's a violation of our separation of powers. We had to take the case. The Chief Justice at that time assigned the case to me, the newest member of the court. It was truly a hot potato. So I and my chambers, we drafted a proposed opinion saying that the 3 strikes law didn't mean what the voters thought it meant. It still gave the judge some discretion to impose sentence. The court unanimously issued that opinion. Politically, the reaction was just outrage. Talk show host. The case was on the front page of every newspaper in the state of California. Thwarting the will of the voters. The court had thwarted the will of the voters. That was quite an introduction for me to the role of a judge, it was memorable. But I want to fast forward. Years passed. All of a sudden, the voters decide that the 3 strikes law is perhaps too onerous. We had initiatives on the ballot 2 or 3 times in a row to ameliorate it, to lessen its punishment a little bit, to require at least that the 3rd felony was a violent felony. There are lots of felonies that are not violent. Finally, after the 3rd try, an initiative did pass that required the 3rd felony be a violent felony.
And now we're looking at the issues of mass incarceration, the terrible waste of the human lives and taxpayer dollars and people being locked away for life. Many, I've read, and you probably, obviously, you know all this, that so many of the crimes that people are in jail for are done by people when tend to be quite young, and they maybe haven't got life figured out. And some of these crimes, even felonies, let's face it, can be drug related. They're not really necessarily, depending on your perspective. I mean,
I think your point is that times have changed, and believe me, I've been in the business of judging for long enough. That's one lesson I've clearly learned, how the public mood or perception or appreciation of issues changes. I entered the judiciary in a tough on crime era, and we have moved now, the public and the politicians, to a let's re-examine this, just as you were describing. Let's be a little more lenient, a little more ameliorative. So times change.
Speaking of time, I'm going to glance at the clock. Good. Another case, I'm sure so many of the cases that you dealt with, each one brought its own, maybe, interest, and I wouldn't say fascination is probably the wrong word, but Smith versus Fair Employment and Housing Com. It seems like a fairly mild-mannered case in some level. 1996 it goes back to. It was about a landlord, and I'm sure you know about it. It seems almost kind of quaint. Do you want to give a little?
I'd be happy to. At that time, we have a fair housing law where landlords are forbidden to discriminate on the basis of race, sex, or marital status. And the plaintiffs in this case were an unmarried couple who sought to rent from the plaintiff in this case. And she was going to rent a unit to them, and she found out they were not married. And this offended her religious beliefs, so she refused to rent to them. They chose to bring suit to claim that she was discriminating against them. The case found its way to the California Supreme Court. It was assigned to me. The court ultimately held that her point was that it was in violation of her religious beliefs. So you have a tension here between religious beliefs and fair equal protection laws. The California Supreme Court, in an opinion authored by myself, held that the fair housing non-discrimination provision triumphed, that she was not living in this building. It was a commercial enterprise. She had chosen to invest her resources into that source of income. In the marketplace, she had the option to put her money elsewhere, and this couple had the right to have the apartment, even though by her religious tenets they were living in sin.
Wow, that is an interesting case. So she wasn't even, the landlord wasn't even renting these?
She wasn't living in the unit. I'm not, oh no.
And so it was like this
It was her commercial, but it's an issue that got a lot of attention, and a lot of people disagreed. It's a classic conflict between your religious beliefs and the civil world. And the broader principle is you are entitled to your religious practice and your religious beliefs, but if you enter the civil world of commerce, you have to abide by civil law.
That is interesting because it brings us to our modern world with now that we have gay marriage between men and women and women. Now, I don't know if this was not part of the list of questions to ask you.
That's all right.
But I'm just thinking about the Indiana case and the cases of individuals who don't want to be the photographer for that wedding. Or
oh, absolutely.
Wanna,
well,
like,
the California Supreme Court was not the first state court, but it was early. In two gays brought lawsuit. They wanted the right to marry, and we, the California Supreme Court, held. It was not unanimous, but I joined the majority, that under the state constitution, they had an equal protection right to engage in civil marriage. That was a state constitutional decision by the California Supreme Court. After that, on the ballot was put Prop 8, an initiative measure declaring that in California, there is no equal protection right for gay marriage. Marriage, they didn't put it that way. Marriage shall be between a man and a woman. That initiative passed. In California, a majority of the voters can change the California Constitution. One vote over 50%. So the California Supreme Court's decision was abrogated. So people who got married, then their marriage was invalidated. As time passed, the issue went up to the federal court. And as we all know, I hope, gay marriage nationally from a United States Supreme Court decision is acceptable. Civil marriage, nobody is telling religious institutions what they have to do.
All right. Now that brings up the interface of my thought to ask you regarding the California state constitution and the federal constitution. In your work as a Supreme Court justice, is the primary starting point the California state constitution as it exists, or is it when you make your rulings?
It depends on the issue, but usually our point of departure, if it's going to be a constitutional issue, is the state constitution, which governs everything in the state. However, if it's a federal question about federal equal protection or a federal statute, the United States Supreme Court governs. We have an independent constitution, and California's constitution, in some respects, offers its citizens greater rights than the federal constitution. California could never offer less rights than the federal constitution, but we can offer, and so can any state, greater rights. California has a broader freedom of speech provision.
Can the federal government step in and overrule that?
Then? No, the federal government would never abolish greater rights that a state granted.
Is that right?
But if a state granted lesser rights, then the federal constitution would trump. We also have an express right to privacy in the state constitution. The federal constitution does not have that.
That is, I think that's very interesting, that the California state constitution is saying, okay.
It can give greater protection. The
Greater
federal
protection.
constitution is the floor. Any state can give its state citizens greater protection.
Even than what the...
Oh, yes.
But what if there is a conflict?
If there's a conflict, the federal constitution wins.
And but then of course, then the state could become a, what would you call it, take it to the Supreme Court, file a claim that says, hey, we disagree with this, or it has no power.
Oh, of course. Well, the court wouldn't take it, but the parties would. The parties that are not happy with the result.
For instance, this 5G thing that I mentioned, I want to bring up, but the local...
Yes. Yes. Well, in our gay marriage case, which the voters later abrogated, we were careful to discuss it only under the California Constitution. And the parties argued it only under the California Constitution. At that point, strategically, so I understand, I wouldn't really know, they didn't want it. They were concerned. Sometimes people don't want a case to go up to the United States Supreme Court because they don't want to hear what they think the United States Supreme Court might say. And once the United States Supreme Court has spoken, that's it, period, on constitutional issues.
Let's take a look at another case. Do you have I made a note for People versus Diaz, for instance. It says here that you dissented in a case regarding People versus Diaz, and did you see that?
What is
the
Diaz?
Person's mobile phone.
Oh, yes. Yes. Now that case came to us under the Fourth Amendment to the United States Constitution. No unreasonable search and seizure. And Mr. Diaz was arrested, and they seized his cell phone and took it into custody, and they booked him. And sometime later, they riffled through his cell phone. I think it was a drug case, looking for his contacts, whatever would be incriminating, which they found. So he was convicted, and he appealed to the state court, the Court of Appeal. I don't remember how they held. Now, there's a lone individual, a presumptive drug dealer, He petitions the California Supreme Court to hear his case. We decided to grant review because classic search and seizure, Fourth Amendment law, had to do with your backpack or searching your house or going through your records. New technology, your cell phone that has so much of your life in it, that's a new issue. Do the old principles still apply? The majority of my court, when you arrest a defendant, it's legal to have a search incident to arrest. If they arrested you today, they could search your pockets, search your wallet, look under your cap. And if you had a briefcase next to you, they could look into that. That is search incident to arrest. The rationale being you might have a weapon there, something that could injure the police, or you might be able to destroy evidence. But if they go into your house, they have to have a warrant in most cases. So the cell phone was a new situation. Most of my court, citing classic Fourth Amendment law, said that search was legal. I differed. I said this is new technology. It requires a new look at old principles. And the case was fortified by the fact they hadn't gone into his cell phone immediately. They'd held it for a few hours. They could have gotten a warrant. To get a warrant, you have to show you have reason to think there's evidence there. I was a lone dissenter. That case, not my case, but the issue, came up to the United States Supreme Court, and they absolutely agreed with my dissent.
So right now, at this point, if someone was stopped with their cell phone, police can do all the searching they want if they get a warrant.
Yes, I'm not here, by the way, to give legal advice about what happens if you're arrested with your cell phone. But the United States Supreme Court did recognize that we have a new paradigm here, new technology. You go into a cell phone, you can find your health records, your financial records. Of course, what the police wanted in this instance was his contacts, you know. So I'm not here to say what the future holds after the United States Supreme Court opinion, but I do know that my dissent was vindicated, that this is a new paradigm.
Did you find yourself in the course of your career shifting your perspective on some of the issues that you may have been ruling on when you were a younger person? Not that, or did you
when I was new.
Look at that?
That's a fair question, and I've been asked it before, and my answer is no. No.
I mean, it's a very, the world changes, and I can totally understand how people might make a shift, but that's...
Well, the world changes and new issues, there will always be work for the courts, and new issues come. But on issues that I early had to decide, going forward with more experience, I don't look back and say I would do it differently.
Do you have anything in your back pocket of life that helped set your compass when you were young, that you felt like it was just...
Well, that's an interesting question for each of us. Why are we who we are? My first job was in the Civil Rights Division of the Department of Justice. I had taken a seminar. California then was a backwater. We really, in the 50s and 60s, well, the 60s were different, but we didn't understand, speaking, I guess, for myself, what the South was like and what was going on. And my consciousness was raised, and it was a very exciting era. And we were in Washington, where I'm much closer to the issues of the day. We would watch on television, so would the nation, what was going on in the South in that era. Bull Connor with his fire hoses and attack dogs on peaceful marchers. And the governors in the South, Orville Faubus and George Wallace, and there are others, blocking the schoolhouse door. The politics were, if we think we're divided today, we have to remember we have been divided before, deeply so. I responded to that, but why I did, why I have the views that I do, that's a deeply philosophical, imponderable question. But each of us, to go back to the beginning, bring who we are to the court, But as I say, I've signed on to opinions that I wished had gone other ways. So.
And so there aren't any opinions that you would have gone back and think, well, what, maybe I could have,
No.
no.
And I want to add to that
Mm-hmm.
when you're doing a case, that's the case you're living with, although you're working on multiple cases. You give it your best shot, and you have the assistance of your very gifted and talented staff, judicial attorneys, and your colleagues, and then you move on. So I've never decided one that troubled me so much that I thought, did I do it wrong? If I did it, that means I had a majority. There were other fine minds that were joining in what I had to say.
Now that you're no longer a judge, do you find that you're still, in essence, a judge? I mean, is that who you?
I find that I perhaps speak a little more freely. I find that I certainly have a perspective on the responsibilities and on the courts. Do I look at life as a judge? No, but I have so much background and knowledge that the usual person in other walks of life wouldn't have. I think I understand the courts. I watch the confirmation hearings in the United States Supreme Court, and I watch who Governor Newsom appointed to replace me. And I'm just very interested in the courts, and I understand the courts. I care deeply about them. There are some states, I should say, where the elections for judges are contested. Anybody can run against a Supreme Court judge, anybody. And in some states, not California, I think we have the best system, may it stay that way. Large, large sums of money come in from out of state to elect a Supreme Court judge. And that's very, very troubling.
Here into California now?
No, California, well, I'm not an expert
okay.
on who's, but other states.
Oh, in their systems.
Yes.
Because of the up for election, which does
Yes,
seem to be.
and they're looking, they see what cases for their industry or their product are coming along, and they want to put somebody in who they think will be favorable to their point of view. But I'm talking about millions and millions of dollars from out of state, but not yet in California.
Well, it does seem to be.
It's frightening.
Terrible, yeah. I mean, just to be so manipulative, it's just the worst thing one can think about politics, then to put the judges in the mix of that too. Does seem to be
You don't want it.
For any other person in the
You don't want it.
Now, is there anything when somebody gets elevated, at least even to the realm of consideration to be a Supreme Court? Is that part of the California Bar Association, or how does that get your name in that?
Oh, well, I think for everybody it's different. But for the Supreme Court, one thing you don't do is you don't apply. It's just bad form.
I would imagine.
Yes, but you can apply for the Court of Appeal. But usually, if you've been in the world of the law, there are people who are interested in you and advance you. What else? So you don't apply.
Yeah.
But if you're invited to apply, as I was, to the Supreme Court, then you apply, and there's a big application, and you have to list cases that you've decided or that you've argued, and you have to list names of people who know your work, and there's lots of background. There is a bar committee that investigates you, your character, your background, your legal stances. So there's a thorough investigation of your background, and then the recommendation is given, the rating and the recommendation is given to the governor. And usually the governor's looking at more than one person. Certainly always the governor's looking at more than one person. And he weighs what he sees and makes his choice.
Interesting. Now, if somebody was really interested in finding out what the California Supreme Court is up to, is there a relatively simple way of looking what's on the docket?
Oh, yes, there is. We have a website. I can't give you the exact site, but you look at California courts or Google California Supreme Court. Absolutely.
Yeah, naturally. In terms of passing the torch to another generation of future jurists and judges and people, any thoughts I'm thinking in terms of, actually well, I won't get back into the dreams of California dreams or American dreams, but what would you say to your grandchildren or their future generations? Kathryn, is there anything that you...
What would I say to them?
Is there anything that you could offer them in terms of your knowledge?
I hope for the best for them. I'm not as pessimistic as your environmental guest,
That's good.
but the world has changed rapidly. I'm heartened by the fact that every generation is born into the world they're born into, and many of them are able to live with it, grow with it, improve it, cope with it. I do have 5 grandchildren. I think they're going to bring good things to the world. I hope the world brings good things to them. I don't know if that's what you had in mind. The law evolves. That's the beauty of the law. And my younger colleagues on the court that Governor Brown appointed are all marvelously diverse, extremely bright, and engaged in the world. And I hope that every fresh generation will continue to be, because that's what we have to have. Where did I read? Somebody said democracy is invented every new generation. Every new generation has to work to preserve democracy.
Well, Kathryn Mickle Werdegar, I thank you very much
Oh,
for
well,
being
thank
my
you.
guest. I think we had a very good conversation. I learned a lot. And,
It was my
I
pleasure.
really appreciate
Thank you
being
for
here.
having me.
Okay,
All
thank
right.
you so much. Okay. Dum, dum, dum.
Is that it?
We are okay. We can just take off our
Oh,
microphone.
it's over.
Yeah.
Okay.
But
Well, I hope you
4
got
minutes
what you
early.
were hoping for.
I think so. My brain was running out of what other questions to ask. And
You
it's okay,
didn't
I
get to
don't-
a lot of the questions that you had
Did I?
anticipated.